Hey, this is Dr. Herskowitz, and this video will be looking at the court system and both the federal and the state level. We're going to hit the state level pretty quickly on this video, but please take the time to review it on the text. Okay, learning objectives will be to recognize the role of key personnel associated with the courts. You're to know the organization of the state and federal court systems, primarily the federal court system, and we will then go over and discuss the power of judicial review. Marbury v. Madison is discussed extensively this week. There's both discussion groups and two different videos that you need to look at to better understand that case. Okay, judges and justices. These are the individuals who actually operate the courts. Judges are the trial court persons. They determine the rule of law in a case. They run the case. They oversee the selection of the jury. They are the power that be in the courtroom. Nothing happens without their approval. Justices are the reviewing court persons. They are the judges, if you will, in the appellate court system, including the Supreme Court. So the judges are operating at the initial trial court level, and justices are the judges that are used in the appellate process. And they decide the appeal of a case based on the review of the law, not the facts. The judges in the trial court determine the actual facts. Okay, so jurors. The jury is a fact-finding body. Its trial by jury is guaranteed in the Bill of Rights. It may be waived, but it has to be waived by both parties, both the plaintiff and the defendant. Juries, a trial jury that returns a verdict in a criminal and civil case, they consist of 12 persons, although some jurisdictions and some types of cases will allow a smaller number of jurors. The decisions must be unanimous. Otherwise, it is a hung jury and the trial goes over. The reason for the determination by the jury is not provided. The jury gets up and they state whether the person is guilty or innocent, and they refer to whatever the judges ask them to determine. So they do not have to, and they do not give any kind of a rationalization. What happens in the jury room is very confidential and strictly left to the jury itself. Lawyers, we've all heard of lawyers. They serve as representative advocates for the parties in the action in the legal case. They represent the plaintiff and the defendants. They help juries and judges to make decisions. They present evidence. They give their interpretation of the point of law, and they make their arguments. Obviously, having a lawyer on each side, each one will be working diligently to prove their case. And through this process, the jury is able to determine what the facts are, and the judge is able to apply the appropriate law. Primary duty is to administer justice. They are unfortunately often more driven to win a case than they are to administer justice, but that is their position. They are officers of the court and subject to court rules and procedures. Lawyers are also licensed by the individual states. There are no federally licensed attorneys. They must take the state bar exam, and then they are allowed to practice in that state where they have been, where they've taken the bar. After they are admitted to the state bar, they may then apply to practice before the federal court. But there are no licensing. They are approved for each court, each appellate district, and also to practice before the Supreme Court, but they don't have any tests other than being a licensed lawyer in their state. Okay, lawyers serve as counselor, advocate, and public servant. Rules of evidence provide that whatever is said to a lawyer is absolutely privileged. That means that nobody else can go into a court and demand a lawyer disclose what their client said. It's attorney-client privilege, much like doctor-client or doctor-patient privilege. This forbids a lawyer to reveal confidential facts and to testify against a client. Okay, so what is the organization of the court system? Well, we have the trial court, we then have the appellate courts, and we have the Supreme Courts. This basic structure is the same in federal and states. Every one of the courts is subject to subject matter jurisdiction, which gives them power over a specific issue. Subject matter jurisdiction means that the court has the legal right to hear the issues involved in the case. Jurisdiction can be limited to a subject or to where the parties live. For example, subject matter jurisdiction would be probate court, which deals with wills and estates of deceased persons, traffic courts, juvenile court, bankruptcy courts. These are all special purpose courts that have special subject matter jurisdiction. Some matters may only be heard in a state court, some matters only in a federal court, and some matters in either federal or state, depending on which court the plaintiff brings the action. We'll go into greater detail of that later on. We're not going to go over a lot of detail on the state system. There's a couple of pages in the text. I want you to make sure that you read that, look at it. But this is a typical structure of a state court. Down here you'll notice there is a comment made about general jurisdiction in law and in equity. We're not going into that in great detail, but historically in the when the court systems were just being formed in the UK and then Britain, there were two types of courts. One that applied the law from the laws that had been passed by the king or the prime minister or the various judicial bodies. And then there was also a court of equity, where there were things not covered by the law that was just equitable to do it a certain way. And those courts had been merged. We're not going to get into that in great detail in this course, but do understand that there are cases that deal with law and cases that deal with equity. Okay, federal courts. Federal courts arise out of Article 3 of the Constitution, and a federal court is restricted. It may only hear matters that are covered in that are allowed in the Constitution. The Constitution specifically states if there is a matter that is not dealt with in the Constitution, it remains the right of a state. And so the federal court system follows that, and it answers questions of federal law. It deals with cases where the U.S., United States federal government is, or a member of the federal government is a party in the lawsuit. It handles disagreements between states, not just between citizens of states, but actual one state suing another one. And then citizens, suits between citizens of different states. So we'll cover two of these just now in federal questions and diversity in the next couple of slides. Okay, federal questions. U.S. constitutional issues. This is a question that a federal court will be able to resolve if it's a matter dealing with the interpretation or application of anything in the Constitution. Likewise, it deals with any federal statutes that have been passed by the Congress. And there is no dollar limit. It can be as small or as large as necessary. So a federal question is a subject matter jurisdiction for a federal court. There's a concept of diversity, and diversity is where there is a case between citizens of different states. And that means that all of the plaintiffs must be different from different states than any of the defendants. That's called complete diversity between the parties. You can have more than one plaintiff from the same state, but you cannot have a plaintiff and a defendant from the same state, otherwise it becomes a state matter. This means that any case dealing with any matter that satisfies the diversity issue may be heard in a federal court. Each claim must be at least $75,000. That's been increased substantially over the past few years, and it's now currently at the $75,000 limit. And this is to guard against bias that one party might have if they're being sued by somebody in another state. This is a basic chart showing the structure of the federal court system. You have primarily the cases that we're going to be talking about come from federal district courts, but you'll notice there are other initial courts of first jurisdiction, tax courts, administrative, bankruptcy, etc. All of these courts can then appeal their cases to the Court of Appeals. And then the Court of Appeals would have their cases appealed to the Supreme Court. Also, the state courts, if it has gone up to the Supreme Court in the state, it may then be appealed to the U.S. Supreme Court. Otherwise, the Supreme Court does not hear any state matters. The Supreme Court is not obligated to take any case. It must, the party wanting to have their case heard must file a writ of certiorari, and then the court will decide whether or not it wants to hear it. The district courts, they are the trial courts in the judicial system. At one court in every state and the District of Columbia, these are the cases. These are the courts where federal cases start. If one party is not satisfied with the outcome, it may appeal. There are 12 districts, 12 courts of appeal districts, and they must accept an appeal from a federal court in its district. So you have these 12 districts. If I'm in the first district, I cannot select and try to appeal in the Ninth Circuit or vice versa. The Ninth Circuit is California and one of the most active appellate jurisdictions in the legal system. It rules on matters of the law that affect the case, not on the facts. Here's a quick pop-up quiz. Generally, the role of an appellate court is to answer the questions. Take a minute. You can stop this. Okay. The answer is C, to review questions of law. Okay. Decisions by the U.S. Supreme Court. Review of any case must be submitted to the Supreme Court, and it is free to accept that appeal or not to accept it. And by submitting it, it's a writ of certiorari, and the Supreme Court will then accept the writ of certiorari and accept the case. But as the text mentions, very few cases are actually accepted by the Supreme Court. It resolves cases involving major constitutional issues or the interpretation of federal law. It will also take cases where there are different outcomes on similar cases applying the same law between different judicial districts. You can actually have the Ninth Circuit ruling one way and the First Circuit or the Second Circuit ruling a different way. And the only way that conflict can be resolved is through a decision by the U.S. Supreme Court. The state courts, no cases from the states will be reviewed by the U.S. Supreme Court unless the case has gone through the state Supreme Court. Power of judicial review is a major topic this week. We have a lot of discussion of Marbury versus Madison and judicial review. It's the ultimate power to invalidate actions by the president or by Congress given to the judiciary, and that is taken care of by the Supreme Court. Judicial restraint is the power that this power of judicial review should not be used to create new laws, and judicial activism. If you think that it doesn't have any impact, look at the National Federation of Independent Business versus Sebelius. This was the Obamacare case recently. Okay, I think that is all that we have for this video, and I will continue on with the other chapters as we move forward in the course. Thank you very much.